from the college by the lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Welcome to the 6th week in our 8-week series entitled Know the Law. On this 6th program, we're going to discuss the area of law called personal injuries. And we're very fortunate to have two guests that are highly qualified to deal with this. One of our guests practices in this area mostly on the plaintiff side and the other one on the defense side. And so that will be most informative to you to see both approaches to this issue. I first of all welcome to the program Mr. Kenneth B. Howard, who was with us on our very first program of this series, and when we discussed when do you need an attorney. I would like to repeat some of his very distinguished background. He holds a BS degree in mechanical engineering from the General Motors Institute in Michigan that he received in 1967. And he has a doctorate in jurisprudence from Wayne State University in Detroit, Michigan. He has practiced law in Michigan and then came to Idaho and practiced in Boise, and now since 1978 practicing in Coeur d'Alene. Mr. Howard also is a member of the Idaho State Trial Lawyers Association and served as president of that association in 1987 and 88. He is also a member of the Board of Governors, or was in that position from 1988 to 1993 of the Association of Trial Lawyers of America. He's admitted to the bar to practice in a number of states and also before the United States Supreme Court. Once again, Ken, it's a pleasure having you on the program, and thank you for taking this time to be with us.
Thank you for having me, Tony.
And I'm equally pleased to have on the program Susan Servic, who is a partner in the law firm of Quain Smith, Howard, and Hall. She holds a BA degree in political science from Boise State University, received in 1982, and she holds a doctorate of jurisprudence from the University of Idaho, received in 1985. She has also been admitted to practice law in the state of Idaho and the federal district courts of the Eastern District of Washington. She has had experience also from 1985 to 1988 in the Public Defender's Office in Kootenai County, and 1988 to the present is with the law firm that I've indicated. Welcome, Sue. It's a very great pleasure to have you on the program.
Thank you, Tony. It's nice to be here.
And I should identify for our viewers that Mr. Howard usually is in this area on the plaintiff side, and Ms. Servic on the side of the defendants. And with that, I welcome to our program the regular panelist, Janelle Burke, who is also an attorney in the state of Idaho and is the law clerk to Judge Heyman of the 1st Judicial District of the state of Idaho. And I shall ask Janelle to commence the questioning.
This area that we're talking about is personal injury today. Can you tell us, what is a tort? Perhaps people hear that term and they don't know what is meant by that.
Well, I think Sue described it well earlier. She's the one that said that it was a French word meaning harm. Is that correct, Sue?
Yes.
But more specifically, it involves injuries to the person, and traditionally we think about it as some kind of a broken leg or a broken arm, but it's more than that. It could be injury to reputation. It can be libel and slander. It can be other things that are not necessarily an injury to the body as we normally think of it. So it expands the entire range of injuries to the person.
Although we're going to talk about a number of areas here today, and that can include such things as dog bites, it could include slip and fall at a supermarket or on someone's property. I'd like to use the example of a car accident right now, because that's when where oftentimes people do suffer personal injury. Suppose someone is involved in a car accident and they feel like they have not been at fault, and of course they've gone through, first of all, the normal channels, and you might want to just say a word about that, trying to resolve the dispute informally. But then beyond that, what happens?
Well, certainly at the time of the occurrence itself, both parties, regardless of whether they think they're at fault, should exchange information so that everybody has information about who was involved in the collision, and get driver's licenses and addresses and telephone numbers so that you can communicate back and forth in the event some problem arises and you need to follow it up further. Apart from that, you need to notify your insurance company, even if you think you're not at fault. That's for several reasons. You have different kinds of coverages under your automobile policy for medical payments, as well as for, if you're at fault, for paying the other party. And sometimes if the other party's not insured, you have underinsured or uninsured motorist coverage, and all of those coverages require that you let your insurer know right away so that they can go out and investigate the claim. So that's one of the first things you should do, and I think that's regardless of which car you're in or which party you are, is notify your insurance company to make sure that you cement in place your rights under the policy. After that, it's a matter of making the claim to the insurance company, the appropriate one. If you think you're not at fault, you make a claim also against the other person's insurance company. Get in touch with them. If it's a minor injury, maybe property damage without an injury, it might be something you can resolve yourself by getting some estimates with regard to the damage of the vehicle and trying to work out an amicable settlement directly with the insurance company. If there are injuries involved, clearly you should immediately seek medical attention and make sure that you're properly treated. I mean, the bottom line in this whole thing is you want to get well and you want to get back into society. And so you go out and get adequate medical treatment in order to make sure that you heal as quickly as possible. If it's the kind of injury then that you feel that you're entitled to compensation for and the other party was at fault, then you can try and negotiate that with the insurance company if it's a simple case. And quite frankly, I'm not discouraging. I would encourage people to try and do that if it's a reasonably simple, straightforward case. Many of them get to be less simple and straightforward, and so then you need to go seek a lawyer's assistance.
So now, suppose that you are the driver of an automobile and the accident occurs, and you think you may be at fault. What are the kinds of things that what is the advice you would give to that person? And you might also talk a little bit about negligence. I think a lot of people think, I didn't mean to, and therefore it's not my fault, or somehow I should be excused. At what point are you negligent under the law?
Well, there are a couple of things that come to mind immediately after an accident. One thing is that the parties should, in addition to the things that Ken has already mentioned about exchanging information and getting those things together, a person should also, if there are any witnesses that saw the accident, try to get their names and get their phone numbers and gather all of that sort of information that's only going to be there right then. Additionally, if it's at all possible, try to get maybe some photographs of the accident scene. The police may come and they may do that as well. But if you have a camera, or if you're able, that's not a bad idea, especially if you're in an accident where the conditions are changing, like during the wintertime when there's been snow on the ground and the skid marks or whatever are only going to be there for a short time. Another point, things that people should consider right after the accident, regardless of how you feel about whose fault, is to avoid any discussions of fault. Exchange the information, do all of that, but try to avoid getting into any kind of arguments or discussions about the fault. That's something that can be discussed later if it's appropriate, but I would encourage people to avoid that at the time of the accident.
Okay, can you talk a little bit about what makes negligence?
Sure.
What is it? And maybe Ken can add anything that he thinks of as we go along.
Sure. The area of tort law is very large, and it includes several things. One of the things it includes are intentional torts. And intentional torts or intentional wrongs are things like assaults, batteries, false arrest, things like that. And those are all torts that people can end up involved in civil litigation. There's also an area called negligence. Negligence are those wrongs that aren't intentional. A person doesn't have to intend for a wrong to happen to have it be negligence. One definition of negligence is when someone acts in a way that a reasonable person would not have acted, or in a way that acts in a way that a reasonable person would not have done, and that is the standard of negligence. So the point is, it doesn't have to be intentional conduct in order for the conduct to fall within the idea of negligence.
Yeah, I think maybe in addition to that, it's important for people to understand that negligence doesn't mean you're a bad person, that you have some kind of a reason to do this. Negligence is failing to do what a reasonably prudent person would do, and those are the words that the law uses. But in practicality, if I was sitting here and I was talking and getting very animated and waving my hands around and I poke Sue in the eye, I would not intend to do that, but it might be negligent for me to do it because I shouldn't be sitting here waving my hands around in that closer proximity to somebody where I might injure them. If I'm mopping a floor and I leave it wet and somebody's walking in and I don't tell them, by the way, the floor's wet, look out, that may be negligent. Same thing with running a stop sign. Maybe I didn't intend to because I didn't see it, but that's negligent. So we're not talking about somebody who does something intentional for the purpose of hurting somebody else. We all, at some point in time or another, are negligent. We are. Fortunately, most of us don't cause injury to somebody else when that negligence occurs. And the only time that we see it in lawsuits generally is when those come together, that there's some kind of a negligent act, some kind of failure to use reasonable care coming together with an injury resulting from it.
Certainly litigation oftentimes can be very expensive, and in particular if it's a major type of injury to a person or a group of persons, and that litigation may go on and may even be appeals, and it can become very expensive, particularly to the losing party. This question is directed to both of you. When someone comes in to your office, Ken, and they're going to be a plaintiff, or they're considering that possibility, and someone comes to sue and finds out they're about to be sued, what kind of advice do you give to potential clients about forewarning them that it's very expensive? What I'm trying to get at is that some injuries are minor in the sense of the injury to the person or even their reputation, and others could involve very serious and lots of money. When should people consider litigation? When should they not? And I have another point to make, and that is we hear among the general population all the time that people are suit happy. They love to sue. Kind of guide us in what should and should not possibly go to court.
Okay. The whole idea of a lawsuit, as we understand it, and we use that term as a threatening term in our society anymore. I'm going to sue you. You know, if you don't do this, I'll go to my lawyer and we'll start a lawsuit against you. And the way we've used that term now is to raise alarm and concern in somebody else that they ought to comply with some kind of a standard of conduct, I guess. But in reality, all a lawsuit is trying to resolve a problem, trying to resolve a dispute that people can't resolve between themselves. So if that's what it's supposed to do, then you ought to try and resolve it without the need for lawyers if you can. And in talking to a client initially, that's one of the things you look at, because lawsuits are expensive. They're expensive because the mere fact that you have a lawyer involved means that you're going to have to pay the lawyer. Immediately, it starts to get more expensive than it should be if you can resolve it yourself. The fact that there are costs involved which are separate than lawyers' fees. We have to pay court reporters for their transcripts. We may have to pay witnesses that come in. Doctors and expert witnesses require to be paid by the hour for their testimony taken away from their regular employments. There are a lot of costs that are involved too, and these things can build up. So you tell the client early on that the reality of the lawsuit is that if it's a small injury, a minor injury, you might be able to resolve it through small claims court. You might be able to resolve it directly through some kind of a settlement with the insurance company, or if there's not an insurance company, directly with the individual. And if it is more serious, then you have to help the client understand that some kind of a choice has to be made at some point in time. It may not be worth going through the aggravation of a lawsuit. Let me tell you, for plaintiffs and defendants alike, it is a stressful situation. It is not something that's easy to do. And it doesn't mean just because the plaintiff starts a lawsuit that they're going to get some money. That doesn't happen. So it's a stressful, expensive sequence of events that you're initiating, and you've got to tell the client about that so that they can make an informed choice. Do I want to try and resolve it some other way? Do I want to try and settle it? I want to go ahead and file a lawsuit, or I want to go ahead and try and pursue this remedy myself. And you go through the costs and the fees and try and project those out for them, as well as the likelihood of success.
Mm-hmm. And so you're on the other end. Oftentimes there's no choice. They've already been sued and so forth. But what kind of advice can you give in those situations? Or is there a way sometime of stopping that process by the contacting the plaintiff?
You mean for the person who is being sued? Certainly, you know, there are mechanisms to try to resolve things short of going to a lawyer, trying to reach some kind of a negotiated settlement, or maybe bringing in a mediator or somebody from the outside just to try to settle the dispute, short of getting all the attorneys involved. It's again a cost-benefit type of analysis. It depends on how serious the problem is, how serious the accident was, how significant are the injuries, and those types of things. And if it is a case that's complicated, if it is a case with serious injuries, then it may be one that a lawyer does need to get involved and does need to represent you.
If there's a small amount involved, and we say small amount, we often talk in Idaho, and other states may have a little different. We seem like that mark is like 10,000, so forth. Can some of these type of cases go into small claims court?
Yes, they can. The small claims court in Idaho, I think, is a $3,000, $2,000 limit. So for accidents that have a monetary amount under that, small claims court is available, which is a court system set up where there are no lawyers. If the claim is under $10,000, then it can go into magistrate court.
Okay. Janelle Berg.
I want to talk a little bit about damages because one of the things we hear is these personal injury cases are huge oftentimes. And so I'd like to start with Ken again. Are they really very large, and what does a person have to show? Can you just go out there and get rich at someone else's expense, I guess is the underlying question.
Yeah. There's been a lot of press and there's been a lot of talk over the last decade, I suspect, but certainly within the last 4 or 5 years, this tort reform business and insurance reform, where there's been this perception that we're a litigious society, and Tony alluded to that earlier, and that people are suit happy. The statistics don't bear that out. They do not bear out that per capita we have more lawsuits or more lawyers than anybody else. Those statistics are misplaced because some of the comparisons were done with, well, let's say the English countries where they have lawyers broken down into barristers and solicitors. I mean, so when they did the statistics for this country, they were talking about all lawyers because we're both barristers and solicitors in this country. We do both jobs. Comparing them to the number of lawyers in England or in Canada, for instance, they were comparing them only to solicitors. So, I mean, it got very complicated. And then also in terms of the number of suits we file. I mean, it's just not, the statistics don't bear that out. But in terms of damages, that's something also that has to be thought of in terms of regional reality. This is not Florida, Dade County, or Cook County, Illinois, or in Wayne County, Michigan, which is where Detroit is. Those were, and down in Los Angeles, where some huge verdicts have come out of those areas. We haven't had very many million-dollar verdicts at all in this state, and for some horrendous, terrible injuries. So we just don't have the statistics in this state to support any kind of jury awards of large numbers. Certainly there have been very, very serious injuries in this state, but we haven't had that problem here. So it is very difficult in this case, in this state, to get juries to return what I think are adequate awards for their very serious injuries. Generally, the people in this state are very conservative in their awards.
The idea, though, is to make the person whole. Is that correct?
Yes, the idea of the law is to try and compensate somebody for things that are lost. I mean, this is not a lottery. This is not something to get rich. It's to replace something that's been taken away. Now, a lot of people will say, how can you pay for pain, or how can you pay for suffering? You can't get it back. So, but that's not the point. I mean, if you have a Rembrandt painting, for instance, and somebody comes up and tears it apart and rips it up, that doesn't mean that it didn't have some value. I mean, it had some value. It would pass hands before that, and we would buy and sell it, and you can't replace it. But you can compensate the individual for the loss of that painting because we were able to put a price on it. Now, it's a difficult thing to do in our society. We don't compensate for pain very often. But we do have things where we try and we express values in terms of spending money to avoid injuries and avoid pain. But we spend millions of dollars to avoid having the astronauts die in outer space, millions of dollars just for their safety. So there are ways to do it. It's difficult to do, and that's one of the things, one of the difficulties that our system has to address, though, is providing compensation for, and it is compensation, and it is just to compensate for something that's been taken away. The pain that you have to endure, the loss of an opportunity to enjoy life, and that sort of thing.
Sue, I'd like to ask you about defenses that sometimes are employed against a lawsuit. But before I do that, I want just to make one comment. We've talked about small claims court, and that is a jurisdictional thing, and it would vary from state to state and so forth. And so it would be wise if we have viewers out there who are interested that they contact their local courts and find out exactly what the jurisdictional limits would be. Now, on to some defenses. What kinds of things are likely to be asserted against a plaintiff?
Well, in civil litigation, in personal injury lawsuits, usually the defense can be put into three categories. The first would be that the plaintiff is arguing that the accident was the defendant's fault. And the first defense is that, well, it wasn't my fault. It maybe was somebody else's fault, or maybe it was your fault, but it wasn't my fault. The second category of defenses would be that, well, you're not injured. The plaintiff is alleging in their lawsuit that they've been hurt, and one of the defenses is going to be, you weren't hurt. Or your injuries came from some other accident. Maybe you were hurt before, and that's where your injury actually stems. And the third category of defense would be, maybe you're hurt, but you're not hurt as badly as you're claiming. And so with those three categories, there are a number of defenses that fit into those. But for the most part, those are the types of things that a defense attorney looks at when mapping out a defense in a personal injury lawsuit. There are two sides to every story, and there are two sides to every accident. And as the defense attorney, it's your role to represent your client and to talk for him and to put out his side of the story, his side of what happened.
Sometimes we say contributory negligence, for example. What is meant by that? And without getting into too much detail on contributory and comparative, but let's talk first about contributory, and then maybe Ken can just tell us what's meant by comparative. But
Right.
Contributory negligence, what are you talking about?
Well, the way the law is designed is that we compare the fault of the parties. Contributory negligence was the old system that was used in Idaho before we had comparative negligence, but under the contributory negligence scheme, the jury was asked to look at the fault of both of the parties. If the plaintiff was at fault at all for the accident, the plaintiff may be in fact barred from any sort of recovery. Now, Idaho doesn't have that system anymore. We've gone to a comparative negligence scheme, and I guess I'll let Ken explain that.
Well, comparative is sort of a logical step from contributory negligence, because there was some concern about whether or not barring the plaintiff completely because of 1% fault, for instance, was fair. And so what the law did was we established this comparative fault, and we look at all of the participants in the action, whatever it might be, they may have contributed to the injury. And we asked the jury to decide, as amongst all of those actors, what percentage of fault would you put on the different parties? If there's just a plaintiff and defendant, then they would, with 100% of the fault, they would have to share that between the plaintiff and defendant. They might say 50% on each, they might say 60% on the defendant and 40% on the plaintiff. Under the Idaho system, which is different than Washington, and I understand this program goes to Washington and Montana, but under the Idaho system, if you're equally at fault, then the plaintiff gets nothing. It's much like the old contributory negligence. So if you're both 50% at fault, then the plaintiff gets none of their damages, no compensation. However, if the defendant is more at fault, like if the defendant is 60% at fault and the plaintiff is 40% at fault, then the plaintiff will only get 60% of their damages. So if they have $100 worth of damages, they'll get $60. They won't get compensated for their percentages of fault of the 40%. If there are more defendants involved or more parties involved, then that gets split up, but we still have this comparison between the plaintiff and the defendants. The plaintiff has to be less at fault than the defendant in order to receive any compensation.
Now, Sue, sometimes there are multiple defendants. Can you explain what happens in a situation like that? Because quite often there will be a whole bunch of actors in this scheme. Even in a car accident, there's going to be the manufacturer of the automobile, and there may be more than one car. There's going to be a driver. There may be other parties.
Mm-hmm. Well, certainly that'll lead to a bigger, more complicated lawsuit when you have more defendants than just a single actor. Generally, what that means from the attorney's perspective is that it's very rare and will ultimately result probably in a conflict of interest to have one attorney representing several defendants. And so what you end up as a result, as soon as you have several defendants involved, you'll have several lawyers, a lawyer for each defendant. The issues then will depend on the issues that evolve out of that litigation as to where the fault will ultimately lie. How defense strategies will be designed really just depends on the particular lawsuit, and so it's hard to give you a lot of specific rules because that's such a broad area and will just depend on that particular litigation.
Something else that happens in this kind of litigation, civil and a lot of money involved, in most all the cases there isn't a jury, isn't that correct?
Usually, the greater percentage of the cases that are tried.
But sometimes the judge would be deciding the case. In the case of a jury making the decision, and oftentimes juries can be split, what do you need to arrive at a verdict to determine if the defendant is going to have to pay damages?
Under our system, in the state courts in Idaho and in the federal courts, it's different. Because we usually have 6-person juries in the federal court system here. We have 12-person juries in the state court. The state court system, 9 out of the 12 have to agree on a verdict in order for you to reach a verdict. So when 9 of the 12 jurors agree on some percentage of fault and some amount of money to compensate them, then the jury is deemed to have reached its decision, and even though they may have 3 dissenters.
How about federal court when you use 6?
Yeah, federal court requires a unanimous verdict because it's 6.
And it doesn't matter how many, no matter how large the claim, it's always 6 in federal court?
No, if it's a criminal case, it goes back to 12.
Right.
But yeah, the federal court system went to 6 jurors some years ago in all civil cases.
Okay. I have another question because I'm intrigued by this, and it came up. We don't have 2 or 3 minutes left. But when you talked earlier in the program about injury, we think of physical injury, but it also came out that we're talking about libel and slander and character assassination. Could you give us just a brief description, I'll ask Ken first, about how that comes under personal injury?
Well, it is injury to the person because it's the person's reputation or it's the person's emotions or feelings, and so it falls within the broad category of the tort. But the way the law is structured, it's the same kind of proofs too. I mean, essentially, you still have to prove that the elements that, and by the way, one of the things that we didn't talk about, but what the plaintiff has the obligation to do, and they bear the burden of proof. So when they start the lawsuit, that means that they have to bring these proofs forward to prove that the defendant was negligent. The defendant doesn't have to prove anything until the plaintiff has come forward with their case.
So, Sue, in defending a person that's accused of libel, you have some of the same criteria?
Certainly, you're going to look at the same sort of categories of defenses, you know, that I didn't do it, that what I did was not actually a libel, I wasn't stating a fact against you, maybe it was just my opinion, and then you get onto the issues about, well, whether or not they were damaged and all those sorts of things.
On that note, I have to bring the program to conclusion. On behalf of Janelle Burke and our staff, we thank both of you very much. It's been, again, just an excellent and informative program, and we thank both of you for taking this time to be with us. Ladies and gentlemen, I hope you'll be with us again next week when we do program number 7, this 8-week series, and for that program we will talk about the law and public policy. Until then, please have a good week. I am Tony Stewart.